I was reading through the civil rights cases. No, not those civil rights cases. The ones that were argued before the United States Supreme Court in 1883. In 1883, oops, wrong mouse. In 1883, there were a series of cases brought before the U.S. Supreme Court, and those cases included U.S. versus Michael Ryan, Richard A. Robinson and wife versus the Memphis and Charleston Railroad Company. And apparently there was another one that's not named in the final decision. And while Justice Harlan wrote a dissent in which he said, striking these were civil rights laws that were passed after the Civil War to guarantee that people had the right to participate in commerce and the right to vote. They were extensions of the 14th and 15th Amendments. The 13th Amendment freed the slaves. The 14th Amendment gave equal protection to people regardless of race. And the 14th Amendment and the 15th Amendment said that regardless of race, color, or previous position of servitude, you may vote. And Congress has the right to pass laws to enforce these. Congress did pass laws to enforce them. They were called the Civil Rights Laws of the 1860s and 1870s, and they were struck down by the Supreme Court in 1883. This is where Scalia is getting his logic from. I just have to share this with you. This is from the majority opinion. This is the winning opinion in the case. And it was written by Justice Bradley. This is, by the way, the same court, essentially. The makeup of the court is very, very similar to the court that decided Santa Clara County versus Southern Pacific Railroad in 1886, just 3 years later, where they supposedly decided that corporations are people. So here we are at the end of this decision. And they write, when a man has emerged from slavery and by the aid of beneficent legislation has shaken off the inseparable concomitants of that state of slavery, there must be some stage in the progress of his elevation when he takes the rank of a mere citizen and ceases to be the special favorite of the laws. You getting this? In other words, there has to become a time when former slaves were saying, you're not a slave anymore, so you don't deserve any protection. Okay, let me continue. And when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. There were thousands of free colored people in this country before the abolition of slavery enjoying all the essential rights of life, liberty, and property, the same as white citizens. Yet no one at that time thought it was any invasion of his personal status as a free man, because he was not admitted to all the privileges enjoyed by white citizens, or because he was subjected to discriminations in the enjoyments of accommodations in inns, public conveyances, and places of amusement. In other words, before the end of the Civil War, let me just tell you what he just said. And this is the winning decision of the Supreme Court in the civil rights cases of 1883, that before the Civil War, there were freed blacks in the northern states, African Americans in the northern states who were free, and even though they couldn't sleep in the same inn as a white person or eat in the same restaurant as a white person, they did not complain. This is what the Supreme Court was saying. Mere discrimination on account of race or color were not regarded as badges of slavery. If since that time, since the Civil War, if since that time the enjoyment of equal rights in all these respects has become established by constitutional enactment, it is not by force of the 13th Amendment, which merely abolishes slavery, but by force of the 13th and the 15th Amendments. On the whole, we are of the opinion that the countenance of authority for the passage of the laws in question can be found in either the 13th or 14th Amendments of the Constitution, and no other ground of authority for its passage being suggested. In other words, they're saying the Constitution's already dealt with this. You don't need additional laws. Okay, this is what they're fixing to say. You don't need civil rights laws because the 13th, 14th, and 15th Amendments are there. Let me start over again with this paragraph. On the whole, we are of the opinion that no countenance of authority for the passage of the law in question, that's the civil rights laws, can be found in either the 13th or 14th Amendment of the Constitution, and no other ground of authority for its passage being suggested, it must necessarily be declared void. This is the Civil Rights Act. It must necessarily be declared void, at least so far as his operation in the several states is concerned. They struck him down. And the very last paragraph, this conclusion disposes of the cases now under consideration. In the cases of the United States versus Michael Ryan, Richardson versus and Robertson, A. Robertson and Wife versus the Memphis and Charleston Railroad Company, the judgments must be affirmed. In the other cases, the answer to be given will be that the first and second sections of the Act of Congress of March 1st, 1875, this is the Civil Rights Act of 1875, entitled An Act to Protect All Citizens in Their Civil and Legal Rights, are unconstitutional and void, and the judgment should be rendered upon the several indictments in these cases, and accordingly it is so ordered. So that was how the Supreme Court struck down in 1883 the Civil Rights Act of 1875 by saying, hey, time has to come. Let me just read that again, because this is exactly what Scalia was saying yesterday. There must be some stage in the progress of his elevation, his being the former slaves, when he takes the rank of a mere citizen and ceases to be the special favorite of the laws, and when his rights as a citizen or a man are to be protected in the ordinary modes by which other men's rights are protected. In other words, special protection? You don't need special protection. The ordinary law will work just fine for you. Yeah, that worked out really well for like 100 years after this decision. This was 1883.
You're listening to the Thom Hartmann Program. Call 866-987-THOM.
And this is what 1883 is what Antonin Scalia wants to take us back to. You just watch.